Tony DeWitt here, Missouri appellate attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. Today's case involves a relatively unused federal doctrine called the Rooker-Feldman doctrine. And it involves bankruptcy, and it just has a lot of interesting issues in it. So today, that's what we're going to talk about. It's a case called Jeffrey Kogan versus Arnaldo Trabuco. It's decided by the U.S. Court of Appeals for the Ninth Circuit back in August of this year. It's another one of those cases that flies underneath the radar, but it has important implications for people who might be going into bankruptcy or might be affected by someone else's bankruptcy. The case involves legal disputes around the civil tort of malicious prosecution. Malicious prosecution is what happens when someone sues another person or actually criminally prosecutes another person, and the other action is resolved in their favor, and as a result of it being resolved in their favor, they claim that the prior action had absolutely no basis in fact, and that it was prosecuted against them maliciously, hence the term malicious prosecution. The case also discusses the preemptive power of the federal bankruptcy courts and the federal bankruptcy law, and whether state courts can have jurisdiction over cases stemming from and arising out of federal bankruptcy proceedings. The case came to the Ninth Circuit on appeal from a federal district court in Nevada. The district court dismissed Kogan's case under the Rooker-Feldman doctrine, which typically bars federal district courts from reviewing state court decisions. So essentially the doctrine works like this. If you are sued in state court for something, maybe even something that involves federal law, and you lose, you can't run to federal court and say, hey, I had federal questions in this and the state court ruled it wrong, and so I want to go into federal court and litigate it there. Because if it did involve federal questions, you should have removed it into federal court. If you didn't do that, then you don't get to appeal the state court decision in the federal courts. Kogan sought to challenge a state court judgment in Arizona that awarded $8 million in damages against him in a malicious prosecution suit filed by Arnaldo Trabuco. Kogan filed his appeal in the Ninth Circuit, arguing that the Arizona court lacked jurisdiction because the malicious prosecution claim arose from conduct in a federal bankruptcy proceeding, which he argued falls under the exclusive jurisdiction of federal courts. Now, the facts of the case are quite complex. In 2012, Arnaldo Trabuco, a surgeon, filed for Chapter 7 bankruptcy in Nevada. Now, Chapter 7 bankruptcy is liquidation bankruptcy. In other words, take my office furniture, take my property, take my cars, take my house. I'm throwing everything into the pot other than what is exempted under bankruptcy law, and I want a discharge from all of my debts. Jeffrey Kogan was an attorney, and he represented the creditors in that bankruptcy, including the family of a patient who had died after surgery performed by Trabuco. It's very common when a surgeon is sort of a malpractice beacon. They tend to resolve a lot of their lawsuits by filing for bankruptcy. The family sued Trabuco for medical malpractice in Arizona State Court, and as a result, it would have been dismissed or at least placed on hold during the pendency of the bankruptcy. But there is a way to get the case resolved in bankruptcy court. You file what's called an adversary complaint. In other words, you bring the complaint from the state court into the federal court, either through removing it to the state court or just by filing an adversary complaint. And that's essentially what Kogan did. He filed this adversary complaint on behalf of the family, claiming that Trabuco's debt to the family was not dischargeable under bankruptcy law due to willful and malicious injury. One of the problems with this claim is that it's a medical malpractice claim. It isn't a tort for assault, or battery, which can be willful, malicious, and intentional, and for any injury produced by an intentional, willful, or malicious action. It's an action for negligence, but it still is resolvable in bankruptcy. Trabucco eventually agreed to settle with the family, agreeing to dismiss and they of course agreed to dismiss the adversary proceeding. However, soon after that, Trabucco sued Kogan and the family in Arizona State Court for malicious prosecution, claiming the adversary complaint was frivolous. In 2018, the Arizona State Court awarded $8 million in damages against Kogan, the attorney. There are two main legal issues in the case. As I mentioned earlier, this Rooker-Feldman doctrine. Whether a federal district court was correct to dismiss the complaint in this case under the doctrine, which typically bars federal courts from reviewing state court judgments. And then the other issue in the case is federal preemption and jurisdiction in bankruptcy. Whether Trabucco's malicious prosecution claim should have been barred by federal preemption because it arose from actions in federal bankruptcy court, which is under the exclusive jurisdiction of the federal courts. Now, Plaintiff Kogan made several key arguments in this case. The first was preemption. Kogan argued that because Trabucco's malicious prosecution claim arose from the filing of an adversary complaint in bankruptcy, the state court had no jurisdiction to hear that case because it arose in and was strictly limited to that bankruptcy. So Kogan argued that the bankruptcy court had exclusive jurisdiction, meaning the state court judgment should be considered void. And then the issue of collateral attack. He sought a declaration from the federal court that the Arizona State Court judgment was void due to a complete lack of jurisdiction and should be wiped out completely. Trabucco, however, had some arguments to make himself. He said, look, this is the Rooker-Feldman doctrine. He argued that Kogan was essentially seeking to overturn a state court judgment in federal court, which is exactly what is prohibited by the Rooker-Feldman doctrine. According to Trabucco, the district court correctly dismissed the case on that basis. Further, he said, look, we had a settlement. He pointed out that the two parties had reached a settlement in which Trabucco agreed not to enforce the $8 million judgment as long as Kogan did not win his federal case. He argued that this made the entire matter moot. He said, look, we had this agreement prior to going into the federal case that if he didn't win the federal case, I would not enforce the $8 million judgment. But this is one of those issues that's capable of repetition and yet evading review, because the only thing that Kogan would have if he did enforce the judgment was a breach of contract action, and that is going to be expensive and take a long time, and in the meantime, he could have his property rights stripped from him. He could wind up in bankruptcy himself. So he argued that this made the entire matter not moot. The Ninth Circuit applied de novo review, which on here before says that means they reviewed the district court's legal conclusions without giving any deference to the district court. The court also considered whether the Rooker-Feldman doctrine was properly applied and whether the federal preemption doctrine barred the Arizona State Court from deciding the malicious prosecution claim. The court looked at two main legal rules. The first is the Rooker-Feldman doctrine itself, which prevents federal district courts from reviewing state court judgments except in certain narrow circumstances. And then the law on bankruptcy preemption. Bankruptcy is solely a function of federal law. You can only deal with bankruptcy in federal law, and you have to bring all of your actions against a bankrupt person in a bankruptcy court. That's what the system is set up to do, to bring all of the issues associated with this bankruptcy, whether it's somebody who hit somebody with a car and now they've got $2 million worth of damages that they're looking at, or some other claim. It has to come in through the federal bankruptcy court. If you have a claim against the individual, you file that claim. If it needs to be resolved, if there are factual issues that need to be resolved, you file it as an adversary complaint in the bankruptcy court. So the court rejected the district court's reliance on Rooker-Feldman for two reasons. First, the Ninth Circuit explained that Rooker-Feldman only applies when the state court judgment was final before the federal case was filed. In this case, Kogan filed his federal case before the Arizona State Court entered its final judgment, so Rooker-Feldman did not apply. I would also imagine there were some issues with regard to what I would call exhaustion of remedies. He probably had the requirement to raise the issue of bankruptcy preemption in the state court, but of course the state court judge may have decided that issue incorrectly. So he says federal preemption applies, Rooker-Feldman does not. The federal preemption issue was the one that was more important to the Ninth Circuit. They held that Trabuco's malicious prosecution claim was preempted by bankruptcy law. Relying on its decision in MSR Exploration versus Meridian Oil, the court noted that federal law completely preempts malicious prosecution claims arising from actions taken in bankruptcy court, meaning that such claims can only be resolved in federal court. Therefore, the Arizona State Court lacked jurisdiction over its malicious prosecution claim, and its judgment was void. The court concluded that Arizona's court judgment should be void because it conflicted with federal law, and federal law, particularly when it conflicts with state law, is considered supreme because of the supremacy clause of the Constitution. The Ninth Circuit reversed the district court's decision and remanded the case. The court ruled that Kogan's challenge to Arizona State's court judgment was not barred by Rooker-Feldman, and that the malicious prosecution claim was preempted by bankruptcy law. The state court judgment was therefore void, which means that the district court is now going to be required to enter that judgment. Now, the case has some significant implications here. The first regarding federal preemption in bankruptcy. The ruling reinforces the idea that issues that arise in bankruptcy proceedings, like claims for malicious prosecution or claims for breach of contract, or claims for assault and battery. In some cases, even class action complaints brought by a large number of creditors. They have to be resolved in federal court, and they fall under the exclusive jurisdiction of the federal courts. This could discourage parties from trying to bring similar claims in state courts, and it will most likely be looked at as a rebuke by the Arizona State Court, and it probably won't make that mistake ever again. And it also limits state court jurisdiction. The case limits the ability of state courts to hear certain kinds of claims involving conduct in federal bankruptcy court. Individuals and businesses involved in bankruptcy must be aware that any litigation stemming from those cases may need to be filed in federal, not state court. And it also clarified the Rooker-Feldman doctrine that it doesn't apply if a state's court judgment is not final when the federal case is filed, giving litigants a clearer understanding of when federal courts can hear challenges to state court decisions. So like I said, it's a very good decision by the Ninth Circuit. And you don't hear me say that very often about the Ninth Circuit, but this is indeed a very good decision by the Ninth Circuit, because it emphasizes the importance of this federal preemption doctrine in bankruptcy cases, and it limits the ability of state courts to assert jurisdiction over matters that are only properly resolved in bankruptcy court. The Ninth Circuit decision protects that exclusive domain of the federal courts in bankruptcy-related matters and serves as a critical reminder about the preemptive power of federal law. So that's what I have for you today. Thank you very much for watching and for being part of this channel. If you have any questions about this case, drop them in the comments down below, or if you like, you can email me at the address above. I always like being able to tell people at the end of the videos to do something nice for someone, so I'll say that again today. If you have the chance, do a nice thing for somebody. And then come on back down here tomorrow, join me at the beach, and we'll talk about something else that's fun. Hey, as I said at the beginning, none of what I said is legal advice, but let me tell you what, the stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.